Hello, it's John Turner, the head of the Global Mining Group at Fasken, and welcome to our first Fasken Institute webinar in our mining series called Current Issues Facing Canadian Mining. I'm going to hand over to our moderator, Frank Mariage, in a moment, but just for those of you who don't know the firm well, we are a full-service law firm with offices throughout Canada and in London, England, Joburg, and in China. We were recently named a proud official law firm partner of the Canadian Olympic Committee, as well as our previous involvement with the Paralympic Committee in Canada. The firm has received many accolades in the mining sector, but I think when you cut through it, we made a decision long ago that we would be a full-service law firm servicing the mining sector in all aspects. And this seminar series is part of that view. Without any further ado, over to Frank Mariage.
So, thanks, John. Hi, everybody. Pleasure to be here, practicing out of the Montreal office, part of the Global Mining Group. We have a great agenda for you today. The event's going to last about 80 minutes or so. We have 5 panels, five topics to be discussed, which will be followed after that by a Q&A session. We're going to start it off with my colleagues Norm Keith and Elaine Léger, who will talk to us about occupational health and safety issues in the context of reopening. After that, my colleague Andrew House will talk to us about Canadian critical infrastructure and strategic elements, emerging national security concerns and mining. Our colleague Kevin O'Callaghan will after that talk to us about First Nation consulting during the pandemic, followed by Stuart Brotman, who will talk to us about Canadian insolvency processes, M&A in the insolvency context. And then I will finish it off with a brief overview of measures taken across Canada by various governments for exploration and assessment work deadlines. And as I mentioned, after that, we will have a Q&A session for you. So let's kick it off. Let's start with my colleagues, Norm Keith and Elaine Léger, who will talk to us about OHS issues. Norm, Elaine, off to you.
Thank you, Frank and John. Appreciate the opportunity to participate. And the first topic we're going to deal with is occupational health and safety, legal compliance, and risk management. I've got 3 slides I want to cover. Before we get into it, my interest in mining and health and safety really started a long time ago, back when I was a summer student for 2 summers at the Garson Mine, just outside of Sudbury. Was interesting to be a miner as a summer student and to learn a little bit about how that worked, and then after becoming a lawyer, getting into the health and safety side of mining. So let's deal with the first slide. There are really 3 categories or concepts of risk that mining executives really need to be aware of. First, there's the penultimate or the most serious risk, and that's the Westray Bill, the amendments to the criminal code that actually created a positive duty for those in charge of mine and mining operations to take reasonable steps to protect workers. The Westray mine disaster, of course, precipitated the name of the Westray Bill a number of years ago, and we see growing use of this crime, in effect, this occupational health and safety crime, which is based in a criminal negligence standard. So if an individual or organization is alleged to have shown reckless disregard for the lives or safety of mine workers, and if somebody's suffered bodily injury or harm, then there is potential criminal risk. So that's the most serious risk. The charge itself is an indictable offense under the criminal code, so therefore it's not something to take lightly. And the corporation could have actually an unlimited fine. There's no prescribed upper limit for a fine under the criminal code for an indictable offense. And also the very serious jail term or high fines, including up to life imprisonment, is available under the Westray Bill. When you go down the scale of risk from legal liability related to health and safety, we're talking about regulatory prosecution, also known as a quasi-criminal prosecution in Canada, as well as administrative interventions by regulators of stop work orders and interventions if there's a whistleblower or a work refusal. So those are some of the other legal risks. The response to the risk, I'll talk a little bit more about this in a moment, but the concept that the courts have recognized, and it is a judicially, not a statutorily based offense, and that is the notion of due diligence. But effectively, what due diligence is a effective health and safety management system based on a hazard assessment methodology. So we'll go to the next slide. And what I want to help people understand at a high level is that when we deal with any type of hazard, including, for example, COVID-19 as a virus, it requires a hazard assessment approach to be able to establish your health and safety due diligence and therefore the response or defense to various risks, be it criminal or regulatory. So COVID-19, we know, is a hazard that is brought to the workplace. It's not inherent to the workplace like other hazards. It requires mining companies in Canada, governed by Canadian health and safety law, to assess the risk exposure to the hazard. So what that essentially means is whether you were involved in a COVID-19 shutdown or continue to work during COVID-19, your health and safety compliance people need to assess the entry point, because if you can prevent the hazard from coming into the workplace, you've done the first and most important of the hierarchy of occupational health and safety hazard controls, and that is to eliminate the hazard from the workplace. But that's not always possible, but there's some important issues to think about in terms of access control, body temperature screening, questionnaires, and monitoring at that point. Then throughout the workday in the mine, it's not always possible, as I know from an underground miner for 2 summers, to always be, physically distancing from people and some of the other public health guidance that we've heard. But mining companies need to realize that for occupational health and safety hazard assessment, you can look to public health guidance, but you need to do a workplace-specific hazard assessment. And then you get to the point of having done that COVID-19 hazard assessment, building your rules around it, and that's really going to help you reduce any likelihood of an allegation that if somebody gets COVID-19 presumptively at your workplace, that somehow you have failed to take your reasonable precautions or due diligence to deal with it. So we'll just quickly then go to the third and wrap-up slide for me on this topic. Due diligence is often thought of generally in terms of mining occupational health and safety as the quality of your program, your training, your safety equipment, and the execution of it. And similarly, when we're dealing with the hazard of COVID-19 in the workplace, those are issues you need to consider. So you need by law to have a policy, a program, not always safe work procedures depending on the jurisdiction you're in, but those are the starting points. But once that's in place, you need to provide information, instruction, and supervision to workers so that your policy program and safe work procedures are implemented. And then thirdly, and this turns it into a system, you need to monitor, be able to correct and coach people who are not following the rules. And then also, the courts are quite clear, you need to be prepared to hold people accountable and discipline workers who don't follow some of the guidance you put in place. The onus is on an employer to prove due diligence in a regulatory offense. If you're able to do that, you've reduced your legal risk and you've enhanced your legal compliance. So hopefully those concepts at a high level will help you assess the value of your own program and make sure that all the hazards in the workplace, including COVID-19, are properly assessed, managed, and mitigated as the law requires. So next, Elaine, out of our Montreal office, is going to deal with a few more specifics on this theme of health and safety in the mining industry. Over to you, Elaine.
Thank you, Norm. So today I would like to review, this will be a summary review of the rights and the obligation of the employer in your sector under the occupational health and safety in Quebec. If I go to the first slide, you see then the general obligation under the section 51 of the Act respecting occupational health and safety The employer must control and identify the risk related to its workplace. Also, he has to develop the safe working methods, and he has to provide the worker with adequate information as the risk he can be exposed, and also he has to train his employees properly. And finally, the employer has to provide the required personal protective equipment. Then, in other words, usually when we are not in the context of the COVID-19, these obligations, the employer has to elaborate his own guidelines. But in the context of the COVID, here in Quebec, it's totally different because we receive some guidelines, specific detailed guidelines from the CNSST and the INSPQ. If I go to the next slide, then you see, if you can just go, okay, sorry, thanks, Frank. If we go to, we see then we have two specific organizations in Quebec who they receive a specific mandate to supervise in detail all the working method would allow to control the risk of infection by COVID-19 on the workplace. The INSPQ, which we call the Public Health Center, and the CNSST, who is the organization in charge of the health and safety in Quebec, they plan, specific measure for the mining sector. So if you click to the link, then you will have access to all the measures that apply with your industry. And then therefore, it is very important for the employer to follow these guidelines if you don't want, if you want to avoid the consequences that I mentioned in the next slide. What are the possible consequences for the employer here in Quebec? So we have inspector in Quebec, and they can shut down the place, if you're not complying with these specific measure. It's under the section 186, then they have the power to go as far as closing your place. Also, regarding the right of refusal to work, usually, when an employee wants to pretend that it cannot work, he has to demonstrate that he is exposed to a danger. So a danger, it's a real danger, and it is an imminent danger. Then, once again, if an employer comply with the guidelines from the CNSST and the Public Health Center, even, the work may represent a risk for an employee to be infected by the COVID, it will not be considered as a danger because it will not be an imminent danger. And then the right of refusal to work, it must not be granted by the CNSST. Regarding the fine here in Quebec, if you're not complying, once again, you can be exposed under the Act Respecting Occupational Health and Safety for a fine. It could be an individual fine, and for a first offense, it could reach for an individual up to $3,000, and for a company for a first offense, it could reach up to $60,000 for an employer. But after the third offense, it could reach for an employer up to $300,000. So it's very serious. If I go now, regarding, however, the criminal charge, as Norm mentioned, for sure, you have all the guidelines. You will have to adapt it to your place, to your specific workplace. But if you do it, if you follow the guidelines, then you must not be exposed for criminal charge, because for criminal charge, we're talking about gross negligence. Then even if you made a mistake, if it's not perfect, as soon as you apply, the guidelines, and you do your best, and you take all the necessary steps to be sure then the employees will comply with the guidelines, then you must not be charged with criminal charge. If I go to the next slide, you have obligation, but also you have rights. So you can impose disciplinary measure against the employees who will not comply with the preventive measure. And also you have the right to require from your employees to come back to work if they don't have a medical condition. We heard a lot here in Quebec that the people over 70 years old was allowed, to refuse to work. And it was the same thing if you have a personal medical condition. For an example, if you are immunosuppressed, or if you're suffering from a chronic medical condition. However, what you have to know, it is then, if you can apply all the recommendation, including the distancing of 2 meters, you can ask these employees, even if they're older than 70 years old, even if they have personal medical condition, to come back to work if you are sure that in all the time you are able to comply with the guidelines and the 2 meters distancing. And finally, at the beginning, I start with the training. It was one of your main obligation to train your employees properly. So we have the chance, in the context of the COVID-19, we have a program here in Quebec, which is a program to train your employee. If you can be reimbursed of a part of this training, and also with this program, you can also be reimbursed for a part of salary of your employees who will attend to this training. So if I invite you to take knowledge of the program, if you have some activities here in Quebec. Then Frank, I give you the floor.
Merci, Elaine. Thank you. Now we're going to pass it over to our colleague, Andrew House, who will talk to us about Canadian critical infrastructure and critical elements, emerging national security concerns in mining. Andrew, over to you.
Thank you, Frank. Nice to be here with you all today. I've given similar talks to folks who work in other industries, not in mining, people who work in the healthcare industry, for instance, or people who work in food services. And I have to say, for most of you, this will come as less of a shock than it did to people in those other industries. And the simple reason is you're used to, I think, applying a bit of a national security lens to mining because you know the value. In fact, many of you are aware of the value to governments, and particularly to militaries and security services, police, to some of the things that are being extracted from the ground. Frank, we'll just go to the next slide. So what I want to talk to you about today is something called the National Security Review. It happens relatively rarely, and I emphasize relatively, but when it happens to you in the middle of a deal, it can be very traumatic. It can have pretty far-reaching impacts on M&A. In fact, it can serve to scuttle M&A if it's not navigated properly. And this is what we aim to do for our clients, is to make sure that they are able to work with government and sometimes challenge government in the application of national security. It's not a defined term in Canadian law. You won't find any place where the words national security are given a proper and fulsome definition. That's by design. The government needs and wants the flexibility to make those words mean what it needs them to mean in any given situation. For many of you, you will immediately recognize that's not fair, and it isn't fair. It may be in some respects necessary for the government in terms of discharging its first duty, which is the safety and security of Canadians, but it does make the lives of those in the industry much more challenging. So let's quickly look at when national security applies. Again, in the context of M&A, establishing a new Canadian business, and that can be a very simple matter of having employees on the ground in Canada. And so it's important to know how quickly you attract the jurisdiction of the Act. If a non-Canadian entity has a couple of employees working in Canada, that may ground the jurisdiction of what's called the Investment Canada Act. Secondly, acquiring control of an existing Canadian business. And third, and this is a challenge for many, acquiring all or part of an entity carrying on operations in Canada. So here we're talking about a minority share that will ground jurisdiction of the Act. There's no transaction too small for the government to take notice of, including in the mining business. And one of the things the government has done is to say that once it receives notice of the acquisition of a Canadian business by a foreign entity, the government imposes on itself a 45-day clock. It has 45 days to indicate to the investor that it's got a national security-based concern with the proposed deal. And that acts as a form of safe harbor. If you're in the M&A business in mining, or you're working with someone, maybe a foreign investor, this is how you know that you are in a safe zone, is if that clock winds down. You should know that the government is in the process of discussing giving itself more time. That's going to create more uncertainty, and it's something that folks need to be aware of. Frank, we'll just go to the next slide. So exactly what does national security mean? If it's not defined formally in Canadian law, what do we know about national security through the eyes of the government? The list that you see on the right hand of the screen is all gleaned from public sources. Sometimes you really need to know where to look. State level espionage and industrial espionage can be factors in the mining business and in the extractives. In fact, we saw a transaction in the not too distant past where industrial espionage appeared to be a component. But what we're really looking at here is item number 6, strategic, or what's sometimes called critical elements. We may also be looking at military or dual use technology. It is interesting that the same element, and here we're talking about the periodic table of the elements that you're also used to and familiar with, the same element can have a very legitimate and inoffensive consumer use. And depending on how it's used or the quantity in which it's used, it can have a military use. That's classic dual use technology. And really knowing the business that you're in, and by that I mean knowing what you're bringing out of the earth or what you intend to, really is the name of the game. I think we'll go on to the next slide. This is a very interesting area, and I've tried to summarize this. The United States issued in 2018 a list of the elements that it believes are critical to the national security of the United States. Canada has issued a similar list, and this is from the Natural Resources Canada website. We can share this web link in our follow-up materials. But what you see are industrial minerals, which are listed, and things as common as aluminum are on that list, because even though they are relatively common, supply is everything. And here I'll give you the example of ventilators. We are told that aluminum is a key component of ventilators, and we all know the critical importance in the COVID-19 era of that technology. That's an example of an industrial mineral. Moving to the technology minerals, these are a little more exotic and include the rare earth elements. Here, things do get quite exotic. Amongst the rare earths, you have things that are used in the creation of high-velocity munitions and the armor plating that prevents the success of high-velocity munitions. And so if you're in that area, you probably know and have known for many, many years that this is sensitive and it's something that the government pays attention to. If we go across, actually down this list to what's called a battery mineral, this is something that is largely a feature of the current Liberal government in Canada, and the fact that it attaches such significance to a green future. You're well aware, I'm sure, that in the creation of batteries that go in electric vehicles, lithium features prominently, nickel and cobalt are in that equation. Canada has attached actual strategic national security importance to access to those minerals. And finally, the steel minerals, things like vanadium or tungsten, again, no surprise. These are incredibly important to Canada's strategic position in the world. We'll go to the next slide. So again, back to the world of COVID-19, I just want to highlight a couple of portions from a statement made by the Minister of Industry on April the 18th. This is what Navdeep Bains had to say, and I'll just focus on the highlighted portions. He says that some investments into Canada by state-owned enterprises may be motivated by non-commercial imperatives. Well, what's a non-commercial imperative? Well, a non-commercial imperative is an imperative that is motivated by a state interest. So it's not about profit. It is about gaining an advantage by one country over another country. And this is what often fuels both state level and industrial espionage. What the minister was driving at in another portion of his quote, which is the following, that at a time when share prices are depressed in certain industries for certain companies, opportunistic investment, the minister's words, not mine, have become a problem for the Canadian government. We might all agree that opportunistic investment is the name of the game. The government doesn't agree at this time and says it's going to be watching for those transactions, particularly, and here are the highlighted words, those involving state-owned investors. And again, regardless of the value of the transaction. So anytime you have the intersection of state-owned investor and non-commercial imperatives or the allegation thereof, particularly in any of these elements or minerals that have been listed by Canada as being critical, you will see examples of enhanced scrutiny of those transactions. We'll just go to the next slide. Just quickly, this is the timeline for what is anything but a quick process. You see that it can be 200 days. In fact, it can go to more than 200 days, where you mix what's called a net benefit review with a national security review. There, it goes out to 230 days. So planning is everything. And again, we're here talking about the transactional world and its intersection with national security in the mining business. You want to approach the government early. You want to have the conversation with them whereby you're in a place where they know you, you know them, and you can make it clear that your transaction either does not involve a critical element. I should mention that gold is not a critical element. You've heard a lot about gold in the newspapers recently. Gold is a precious metal. Gold matters to a lot of people because it's valuable, but value is not the same as critical. And this is why it's so important to check those lists with the government. In any event, I'm going to stop there, and there may be questions later on, and quite happy to address those. I should mention that coming up on the, I believe it's the 22nd of June, Fasken will address some of these issues around supply chain security, the availability of critical elements in an international sense, including as it touches on our key allies. And so you can watch for that on the 22nd of June. Thanks everyone for your attention.
Thank you. Thank you very much, Andrew, much appreciated. Our next topic is on First Nations consultation. And I'd like to pass it over to my colleague, friend, and partner out of our Vancouver office, Kevin O'Callaghan.
Excellent. Thank you very much, Frank. If you move on to the first slide, excellent. So I'm going to cover a little bit of what the overall context is for the issues that we're finding with consultation in the era of COVID. Talk a bit about what the provinces are doing and the federal government is doing, and then a little bit at the end on kind of general guidance for companies as they try to make their way through this maze. But not surprisingly, and I think everyone has this expectation that COVID has created delays in applications for permits and other approvals and increased time. And that in part is because of regulatory capacity, and in part in the context of First Nations is issues with First Nations own capacity in the context of COVID. And you will have seen in the news the kind of the sharp reaction of First Nations in the face of COVID. You will have seen road closures and blockades, closed communities, bans on alcohol, bans on meetings of more than 4 people. The kind of social distancing structure that many First Nations have put in place are much more strict than you would find kind of anywhere else in Canada. And this stems from 3 dominant and quite understandable factors. The first is the well-known poor medical infrastructure within the communities. The communities have for a long time been asking to be brought up to the same standard as the rest of Canada. And in addition, many Indigenous communities are a long way from the nearest ventilator. And so that adds to the fear, as well as having a population that itself has a lot of and a disproportionate number of the risk factors for things like COVID. So you got the health aspect. The second is a long history of very bad experience with epidemics. I mean, although smallpox seems like it's a long time ago, within the memory of First Nations, it's really not that long ago at all. And that leads us to the last of these key factors, which is oral history. As many of you will know, oral history is critically important to First Nations. And that oral history is embodied literally in the elders in the community, and it's those elders who are at most risk in this pandemic. As one Indigenous commentator stated, the pandemic threatens to erase our community's memory. So you can see why there's such a sharp reaction. And this is despite the fact that the actual impact on the ground of COVID is relatively mild in Indigenous communities. As of May 29th, First Nations on reserve in provinces, so that's the statistic, had only 216 confirmed cases of COVID, 176 of those recovered, 20 hospitalizations, and only 5 deaths. And that's across the entire country. So you can see that the reaction has proved effective. And what that has meant is, though, that reaction has meant a preoccupation within communities on dealing with COVID as opposed to dealing with consultation issues. And so all of that has affected their ability to consult and the ability to get attention to consult. Regulators are experiencing this same thing. So going across the country, BC and Alberta have issued more formal guidance, whereas the rest of the provinces haven't really. But all provinces are experiencing delays, and all provinces have instructions essentially to deal with things on a case-by-case basis, take into account the requests of the Indigenous nations, and provide either extensions or delays to consultation, which will result in delays to approval to projects down the line. So in BC, there's a formal bulletin that was put out in March 27th, where the province said that it would, on a case-by-case basis, take into account requests for postponement, and in making those decisions, take into account the capacity of Indigenous groups, the nature of the activity being consulted on, the urgency of the activity, the nature and severity of the impact, and how far along the consultation is. So you can see there's kind of two aspects to it. One aspect is, what is the First Nation dealing with right now on the ground? The other aspect of it is the balancing on the other side. So how far along is your project? How important is it that things get done right now? What's the effect of a delay to a timeline on the project? So you can see that the balancing is explicitly there in the BC's bulletin. When we move to Alberta, you can see that their focus is kind of they're still doing the balancing, but they're focused more on the project side. And for instance, their key statement in their bulletin on the issue says, "We can practice proven public health measures while keeping much needed projects moving forward." So in Alberta, they've created 2 different tiers. One is an extension, and they've provided a 10-day extension for certain consultations, and for more significant consultations, a 15-day extension. I mean, those extensions in the context of BC, Ontario, or the Canadian context are much, much shorter. However, they have also granted what they call pauses in consultation. They've granted 22 pauses so far. And they're trying to stay away from pauses in consultations and stick to the extensions. And the pauses will last as long as the state of emergency lasts within the province, and then be dealt with on a case-by-case basis thereafter. in Ontario, there is nothing formal like in BC, Alberta, but there has been a call, for instance, from some First Nations in Northern Ontario, went to the media and publicly demanded the province put mining exploration on hold and staking on hold for the duration of the pandemic. The minister did do a response to that in an email to media, in which he stated that it values the ongoing work of the exploration sector, but that it also remains committed to meeting the obligations with respect to Aboriginal consultation. Now, that's in the context of mining being an essential service, but the government was clear that it wouldn't suspend its mining land administration system, but it would deal with issues of delay on a case-by-case basis, and made this statement to close out. The ministry continues to work with the First Nation communities to understand their needs and concerns during these challenging times, and we will use the tools available to us to balance all interests in a respectful way. So what you can see there, and frankly, Quebec is very similar to Ontario in both the way it is managing mining as well as consultation. And frankly, all the jurisdictions, all the provinces are dealing with this in a way that tries to balance and acknowledges trying to balance consultation and obligations to consult with trying to get things moving forward. In addition, on the federal side, there hasn't been a formal response either. However, the experience on the ground is that the federal regulators will grant an extension to basically anyone who asks for it. They've been up to 30 days and then reevaluated. And there is also a serious concern that where decisions will need to go to cabinet in the context of environmental assessments, for instance, kind of in the coming months, that the cabinet is so preoccupied with COVID that those decisions will take a long time to get made. Next slide. So general guidance, what to do on the ground. And the bottom line is that there will be delays, but there are things that can be done to try to decrease those delays. And the first step is always gathering information, going to the websites of the province, the Indigenous group in Canada, talking with a company's contacts at the regulators. They may have already spoken to the First Nation, and speaking to the First Nation themselves. The goal of that communication at the outset is to figure out what is going on the ground in that community and how to assist in mitigating it, so that priority and capacity can be moved over to whatever it is that you need or trying to need to move forward in a timeline that works for you. And often that's a matter of trying to figure out what the bottleneck is. And sometimes that's a technology issue. Sometimes that's a capacity issue. Sometimes it's just a priority issue. But applying kind of flexible and creative techniques of using, replacing in-person with video, does the community need some technology delivered to it that could assist you in getting things to happen on the ground? All of these things can help move things forward, but it's a matter of being flexible and creative. There's no doubt there will be delays in consultation, but for how long will depend on the proactive actions taken now. And that ends mine. Frank, on to you.
Thank you, sir. Much appreciated. We're going to move on to our next topic, being regarding insolvency, Canadian insolvency process, M&A in the insolvency context. Now I pass it over to my my partner, Stuart Brotman. Stuart, the floor is yours.
Thanks, Frank, and hi, everyone. Appreciate you joining us. So I'm going to spend a few minutes talking about how deals get done in the distressed world, with a particular focus on the tools that are available to us in Canadian insolvency proceedings. You know, the mining space is an interesting one in that we swing through these cycles of distress to non-distress with somewhat more regularity than some other industries, regardless of what the larger economy is sometimes doing. And so I'm sure many of you are familiar with some of the issues that arise as we encounter transactions that we're looking to do with companies that are constrained in their liquidity or you know, perhaps near or in insolvency. And you know, the core of the issue that we are looking to address in the tools that are available to us and that we can apply in insolvency or restructuring proceedings is, you know, what to do about creditors who may be owed amounts that cannot be paid by the debtor slash, you know, contract counterparty in most of these, or M&A counterparty in most of these cases that we're talking about, and how do we deal with those advantageously without the acquirer or investor having to pay them in full, where the alternative is perhaps a failure of the counterparty. And so you'll see what I've touched on in the very first slide there is just the different types of proceedings that are available to us in insolvency and restructuring cases that you know, through which we can apply the tools that help with those issues. And so we have in the restructuring proceeding space, which is in each of these cases a process whereby a debtor company remains in possession and control of its assets and its business, and is able to take advantage of a stay of proceedings and the benefit of court orders that can help it address the issues that it may be facing. And then the other basket of proceedings are liquidation proceedings, where in a receivership, for example, the assets and operations of a business are overtaken by a receiver or in different cases, a trustee or administrator in some foreign proceedings. The first piece of legislation that you'll see on the slide there, the Canada Business Corporations Act, some of you may be familiar with it as a non-insolvency or distressed tool. It is not a bankruptcy or insolvency specific piece of legislation. Rather, it applies to all. In the case of the CBCA, Canadian federally incorporated corporations, we also have similar legislation in the provinces, and wherever you see CBCA through this presentation, you can think as well of the Ontario Business Corporations Act, the BC Business Corporations Act, etc. Next slide, please. So coming back to one of my earlier statements, you know, what end do these tools achieve? I've set them out here, those two tools, and I'll get into them in slightly more detail. But what they really allow us to do is to deal with claims of creditors that otherwise would kind of continue with the business or attach to assets that are being sold, depending on how your transaction is structured. And so these tools allow us to effectively cleanse a company, and that may be an overly harsh term, but cleanse a company of creditor claims on closing of a transaction to allow the transaction to proceed. In the case of the first tool, a plan of compromise or arrangement, it is best understood as an alternative to reaching unanimous agreement among all the creditors as to how much they will accept in compromise of their claim. So if we think of the simplest case of a small company with 5 or 6 or 10 creditors, it's conceivable, although perhaps not even practical when you get up to 10 creditors, but it's conceivable that a company in that situation who is looking to effect an M&A transaction could approach each of its creditors and say, if you're owed $100 each and you allow this transaction to proceed, we can pay you 80 or 70 or 60 cents. And will you agree to that? And in exchange for your agreement, allow us to proceed with the transaction. But of course, you know, we don't run into companies with that simple a debt structure or nearly that few creditors with any regularity. And so what a plan of compromise or arrangement allows us to do is to put forward that sort of compromise proposal to our creditors or to the creditors of a debtor or a target company. And so long as we can secure the affirmative vote, a supportive vote of a requisite number of creditors or a percentage of debt, and we'll come to that, then everybody else is bound. And so it's a mechanism that through the publication of a plan and the holding of a vote allows us to achieve a binding compromise of debt without having to secure the specific agreement of each of the creditors, which, of course, among other things, leaving aside the practicality of it, if you were required to achieve 100% unanimity, that gives every single creditor the power and influence to effectively veto a larger transaction. So that's plans of compromise and arrangement. Again, I'll talk in a bit more detail about those. And then we have vesting orders. Vesting orders, these are available primarily in asset sale transactions and allow the Canadian court in insolvency proceedings. And so while it's been done in CBCA plans of arrangement, it's not typically done that way. The court in our Companies Creditors Arrangement Act, or CCAA as we call it, which is similar, very similar to the Chapter 11 process. The court in those sorts of proceedings, in equivalent proceedings under our Bankruptcy and Insolvency Act, and in our receivership proceedings, are able to issue an order in an asset sale transaction that says, when you close this transaction, the assets that are being purchased will vest in the buyer free and clear of all creditor claims. And it gives the purchasing entity comfort that an order of a court that it can hold up in response to anyone who comes along after the fact and says, you owe me the debt of your vendor, to say, no, I don't. The court ordered that I can take these assets, when I take these assets, I take them free of your claims. Now, the corollary to that, from the creditor's perspective, is they will have recourse against the proceeds. And so if assets are sold for $20 million, the creditors stand in line, and in accordance with the waterfall of priorities, they get their share of the $20 million. So in that way, it achieves a similar effect to a plan of compromise or arrangement. And as I'll talk about in a moment, is sometimes where an asset sale can be achieved, it is a far more efficient process for a number of reasons, including that no vote has to be held, and the purchaser does not have to get involved in determining who gets what. They leave a cash, they take the assets, put in their place a pool of funds, and then the debtor company and its creditors can deal with, and the creditors can potentially fight over who gets how much of that pool of assets. Next slide, please. So a slightly more in-depth analysis of plans here. As I said earlier, plans are available in CBCA and other Canadian corporate law statutes, and under the CCAA, our equivalent of Chapter 11. Now, the consideration to creditors, a plan is a contract. It's just a contract that not everybody has to sign. It's a contract that people vote on. And so pretty well, and any consideration that can be given in a contract can be given to creditors in a plan. And by consideration, I mean that which the creditors will receive if the plan is implemented and the M&A transaction is given effect. And it's that which they will receive in exchange for their debt. And so as you see in that second bullet, it can be cash, it can be debt, it can be equity, it can be other securities, warrants, options, the like, or any combination of those things. And it's not uncommon to see a combination of some cash and some reduced amount of debt, and warrants and options and the like. One of the advantages from the perspective of an M&A transaction in the context of a plan is that existing equity can be canceled or substantially diluted. The underlying theory being, if the party to the M&A transaction that is insolvent, by very definition, the fact of insolvency means there's not enough money to pay the creditors. And of course, because equity ranks behind creditor claims, the equity is viewed generally, and this can be argued, but the equity is viewed generally as having no value or interest. And so not only can we, in the context of a plan, extinguish or substantially dilute equity, but in the context of a sale, the court can approve a sale transaction, notwithstanding that the shareholders would otherwise have a voting right with respect to that transaction and approval rights. The court can override that shareholder approval right. With respect to a plan, the voting majorities I mentioned earlier, as I said, they are a tool to bind a minority where you have majority approval. In the CBCA, that majority is, the required majority is not set out in the legislation. In the context of debt, the court will generally order that 66 2/3 in the principal amount of debt outstanding must vote in favor. In insolvency proceedings, CCAA, and the equivalent under our bankruptcy legislation, that majority is established. Creditors vote by class. There is generally a secured creditor class and an unsecured creditor class. There may be more depending on the debt structure of the business. But for a plan to be approved and proceed to court authorization, it must be voted, it must be accepted by a favorable vote of the creditors in each class. It's a double majority, at least 50% plus one in number, representing at least 2/3 in value of the claims voting in each class must approve. If that occurs, then the plan is submitted to the court for approval. It is not a rubber stamp, although it is quite rare for the court to disapprove of a plan that has the requisite majority, that has achieved the requisite majorities on a vote. But it is an opportunity, and the test there is fairness and reasonableness of the plan. It's an opportunity if there is a creditor party who, or a group of creditors within a class who is being unfairly, whose interests are being unfairly disregarded effectively by this plan, to come forward to the court and say, notwithstanding that 66 2/3 voted in favor, and notwithstanding that we were in the dissenting minority, for this reason or that reason, you court should not approve this plan because it is patently unfair or unreasonable for you to do so. As I said, seldom does that argument succeed, but there have been cases where it has, and it is open to the creditors, and court approval is required. And as I mentioned earlier, a plan as opposed to a sale and a vesting order is a more costly and time-consuming process, including because in order to determine the claims of voting creditors, the debtor company must run a claims process whereby it solicits proofs of claim from all of its creditor groupings. Those creditors are entitled to submit that claim, and they're generally given a period of weeks to do that. And there can be a dispute period after that where the claims asserted by creditors don't accord with the records of the debtor company, or for some other reason they've been inflated, or there's questionable basis for the claim. There is an opportunity to object to those, and that can be quite a time-consuming and costly process. And then, of course, there has to be a creditors' meeting convened, which again is also several weeks generally of notice, and adjournments and the like can drag out the time frame. You're talking, in most cases, several months at least to achieve a plan. And so in the context of closing an M&A transaction where, for example, an acquirer or investor is effecting its transaction by way of funding a plan. So funding the amount that will be distributed to creditors, for example, in exchange for new equity in the business, and an extinguishment of all existing equity whereby you could take over the shares. That's one structure where we use a plan. That would be a several months long process to put forward the plan, establish the claims of creditors, have a vote, and then implement. Next slide, please. So vesting orders, I've touched on some of this before. Supportive of a sale transaction by vesting free and clear. No creditor vote is required, and for that reason it is a much faster process, but the court must approve the transaction. Accompanying insolvency proceedings is prohibited except with court approval from entering into sale transactions outside of the ordinary course of business. The court will assess the transaction less on its terms and primarily on the basis of the process by which the transaction was arrived at. An insolvency court is concerned with market value, and that market value is being obtained. It is far less persuaded by valuations, for example, than it is the actual open exposure of assets or businesses to the market. And so for that reason, the court will want to be satisfied that the process was open, was fair, and gave an opportunity for the market to establish the true value and price of the transaction. The court, in assessing a bid, will not only look at the ultimate price and the process, and it will allow for the approval of a transaction that perhaps wasn't the highest in purchase price, but rather had on a number of factors, including closing risk, time to closing, deposit, financial wherewithal of a purchaser, and the like. It was the best offer received and the best transaction available in a process with which it is satisfied. Sale transactions and vesting orders are, this is the flip side to my comment earlier about plans, faster and less expensive, no claims process, no plan, and the distribution occurs, as I said earlier. The investor buyer doesn't have to worry about the distribution. It simply gives a pot of money or other consideration, and the debtor and its creditors can fight over that for as long as it takes them to figure out who gets what. But we as buyer would close our transaction and move on free of those claims and free of any distraction relating to who gets how much of the purchase price. Next slide, please. So speaking of the process, if you're involved in an insolvency marketing process, they generally are referred to as SISPs, or sale and investment solicitation processes. As I said earlier, they are critical to court approval of an ultimate transaction. They're also desirable from the perspective of the board of directors of a distressed company to protect themselves from liability and criticism, to ensure that the process was well run, open, and fair to all parties. Generally, the process is laid out, if not court approved, at the outset in an insolvency case or restructuring proceeding, and that process generally has timelines, procedures, information that must be contained. Often what you will find in a CISP in a distressed or restructuring case is a two-stage process in Canada. These are sealed bid processes in most cases, where non-binding LOIs are required by a certain date, and then qualified bidders who have submitted acceptable non-binding LOIs are then invited to submit a binding purchase offer on the basis of, and sometimes with further due diligence opportunities and the like. A characteristic of these processes is very tight timelines for the most part, and diligence is generally required to be done quickly, and as I say, sometimes in two stages. Binding offers in these processes are generally required to be condition minimal, with very few conditions, certainly no financing conditions, certainly no title conditions, although vesting orders help with that. And at the binding order stage, once the order is submitted, generally no or very limited continuing diligence conditions. I should also mention, and it's not in the slides, just drawing on Andrew House's presentation a moment ago, we cannot, through vesting orders or otherwise, avoid Investment Canada Act sorts of issues. And so some engagement with the regulators on that front is often required in the context of a transaction involving a foreign entity. The sale or investment solicitation process, as I said, if it's being administered after the filing has occurred, we will often go to the court and ask the court to approve it up front. It takes away some uncertainty and risk, although the professionals who structure these things are generally quite good at predicting what the court will find acceptable and have the confidence of the court. But if we have the transaction, the CISP process approved up front, it gives us greater certainty that when we get to when we reach agreement on a transaction and we bring it to the court for approval, having already approved the process, so long as we carried it out in accordance with the court's requirements, the risk of a court denying approval of a transaction once we've gone through the process of receiving LOIs, soliciting and receiving second round bids, binding offers, negotiated binding offer, and be done with it, we minimize the risk that we have to go back to the drawing board. And in most cases, we're successful in doing that, and very, very seldom does a court not approve a transaction that was arrived at in a fair process. There is sometimes an auction in our sealed bid processes, far less often than we see in the United States. The circumstances where we most often do see an auction is where there is a stalking horse transaction. If we could move to the next slide, I'll very quickly point out, and then we'll move past it, the one further thing I didn't mention about distress transactions in insolvency cases is not only are timelines compressed, but also they're expected to be as is where is transactions with minimal representations and warranties. And in any event, because you're dealing with a distressed company, as many of you will be familiar, any sort of surviving reps and warranties or indemnities that you might otherwise rely on outside of the distressed world will have no value in all likelihood if your counterparty is insolvent, and will have no ability to honor the warranty or any claim for misrepresentation or breach of warranty. If we could move to the next slide, and I'll make this the last one I touch on, and I won't address everything here, but let me just touch on two concepts there. You'll see in the first bullet the concept of a credit bid, and then in the second bullet the concept of a stalking horse, and I'll deal with them in reverse order. A stalking horse transaction is part of a CISP process that whereby the debtor company will have negotiated a purchase or investment transaction upfront, and in essence, it would be the equivalent of entering into a transaction with a counterparty where that transaction has a go shop clause that allows the counterparty to go to market, and if it's able to secure a higher bid, exit the existing transaction. Well, that in essence is what a stalking horse is. It's generally built into the CISP, the sale or investment solicitation process, where a transaction has been negotiated on the front end, and any party who wishes to bid against or bid for the assets or an investment in the business, they must bid against that stalking horse bid. They must be able to exceed the value of that stalking horse bid, generally plus a break fee and some expense reimbursement in favor of the stalking horse bidder. We like to use them when we're acting for debtor companies where they're available, not only because they provide for a much more focused CISP, a much more focused sale and investment solicitation process, because you're only dealing with people who could potentially outbid the stalking horse bidder, but also because on the front end, particularly where you've got an operating business and there's risk that customers, suppliers, employees might go elsewhere rather than wait to see what the result of a CISP in an insolvency case would be. A stalking horse introduced at the very early stages of an insolvency case allows us to say to those parties, there will be a transaction. We have one in hand now. All that's going to happen throughout this case is we are going to continue to solicit and maybe find a better offer. But if we don't find a better offer, and in any event, we will proceed with the stalking horse bid. And that transaction is generally approved by the court at the front end along with the CISP. Lastly, what is a credit bid? A credit bid is generally an asset sale sort of transaction where a secured lender, and it's only available, theoretically it's available to everyone, practically it's really only available to secured lenders. A secured lender can, and often it's combined with a stalking horse, make an offer to acquire the business for a certain purchase price. But rather than pay cash to the debtor company only to have that cash returned to it on a distribution as a secured creditor, it says, I will pay my purchase price in whole or in part by reducing my debt. And so, if, for example, a secured lender has a $20 million debt and it wishes to bid $30 million for a business, it could say, my purchase price, my bid is $30 million. I will pay you $10 million in cash, and I will forgive my $20 million of secured debt in exchange. There are many nuances to that, but it is a tool that's often available, and it is a tool that a secured lender will often use in a stalking horse bid to assure itself that it will either there will be a sale transaction that sees it repaid, or it gets to take the assets or get the business. I will leave it at that. There's a couple of other slides there. One more slide there that I think is pretty self-explanatory. Thank you all for your time. Happy to receive your questions at the end of the presentation.
Thank you. Thank you very much, Stuart. Very interesting. So I have the pleasure of closing it off before we get to our Q&A. I have a few information points also before we get to the Q&A session. I do not have any slides for you. My information is, to say honestly, pretty straightforward. It's to look at what measures were put in place across Canada by governments relating to mining permits, mining rights. Obviously, I looked at some major jurisdictions that I focused on. There are 6 of them, coast to coast. You'll see that the measures resemble one another, although they are somewhat different in their application. I think an important thing that you need to know as well is that the province of Quebec was the only province in Canada that did not designate mining as an essential service, which means that when the pandemic broke out and everything came to a halt, not only a mining extraction, operating mines, but also every exploration project in Quebec had to come to a stop. So we were the only province in Canada that where this occurred. Mines were all allowed to reopen 2-3 weeks later, and actually I think it was mid-April, and exploration was able to restart a couple of weeks after that. So let's have a look. Obviously, as you know, every mining act in Canada, they're not called the Mining Act, but mining permits, mining rights are issued under these acts, and they have a deadline. And to keep that right in good standing, you have to do a certain number of assessment work. You have to file for reports, demonstrate the work you've done, and you have to do it within a certain delay to be able to renew your permit. So we'll start off from the west, and we'll make out our way east. So BC was one of the first jurisdictions to come out with a measure. Wasn't the first, but it was one of the first. They came out with an order on March 23rd. I said 27th, I'm sorry. They made it quite simple. They said, we are going to extend every mining claim outstanding, every mining permit, until the end of 2021. So as of the date of the order until the end of December, if you had a mining claim that was set to expire before the end of that year, all of your obligations to register a statement of exploration and development, the registration of the payment, and all these obligations, including the expiry date, all of that has been extended to December 31st, 2021. So that's fairly simple process. Everybody's got the same expiry date for next year. Alberta now did something a little different, actually. Quite different, actually. They were the first ones to come out. They came out with their bulletin on the March 23rd, 4 days before BC did. And what they did is that they are willing to extend mining permits for 1 year. All mining permits that were set to expire between March 20th and December 31st of this year. But for that to happen, if you will hold a mining permit in a mining right in Alberta, you have to ask for it. So it's not an automatic extension. They are willing to consider extension, but by applications, only for those applications that it's received. So you'll see there's a difference there. There's already a difference in between what BC and Alberta has done. If we move our way now to Saskatchewan, now Saskatchewan came out with its decision April 14th, and what they've decided to do was to simply grant a 1-year extension for all mining permits that were set to expire after that date until the end of the year. So it's a 1-year extension, not like BC did until December 31st of the year after. The following year, it's just a 1-year extension to give your. So every obligation you have in the expiration and your expiration your expiry date has been extended by 1 year. Ontario did a similar kind of extension. But there's an administrative process that needs to happen for you to extend your mining claim. They issued their bulletin 3 days after Saskatchewan on April 17th. You have to apply for an exclusion order for your claim to be extended by 1 year. So all claims that are set to expire between the date of the bulletin and the year end, if you are a claim holder and you would wish your claim to be extended for 1 year, you need to apply. There's a process. They have an email address, specific email address for that, and you need to apply 30 days before the expiry of your mining claim. And it's only done by email, and it says they will grant you an exemption of up to 12 months, which means that if you wish, you could ask for a smaller extension. I'm not too sure what the benefit of asking for a smaller extension is, but at least it says up to 12 months, and it has to be done by email, and you need to do it 30 days before the expiry of your claim. So already we've just gone over 4 jurisdictions that have similar measures, but somewhat also different in application. If we go on to the province of Quebec now, Quebec, again, similar process to what Saskatchewan has done. They remember, as I mentioned at the beginning, is that Quebec is the only province in Canada where mining was not designated as an essential service and where all mining activities came to a halt in March. They issued their bulletin on April 9th after tremendous pressure from the mining industry, and they elected to grant a 12-month extension to all mining claims that were set to expire between April 9th and December 31st of 2020. So it's a simple 12 months extension of all of your mining claim. If we look now to the last province that I covered in my research to look at various measures that were enacted in Canada, it's New Brunswick. New Brunswick came out with its decision, I think it was around April 3rd, and they put all mineral claims under protection status, meaning that all claims that were set to expire between April 1st and December 31st would be granted a 1-year extension, no renewal fees, no work commitments, and just a simple 12 months extension to all that with no obligations to do in relation to that extension. A particularity of that process is that they said every claim holder that had claims that expired between March 17th and March 31st, so after their decision came out, well, they will contact each claim holder personally. The government, the ministry, will contact them and give them the option to renew their claims. So they're the only ones in Canada who, pre-decision have elected to, well, we'll contact the claim holder and see what he wants to do because his claims expired. So that means that any work also that was carried out or is being carried out in 2020 you will be able to apply that to 2021 for your renewal obligations, considering that they've extended it for a 12-month period. So those are the measures that were put in. So 6 provinces. We covered the major mining jurisdictions in Canada. Obviously, a lot of the question that comes to mind for many companies, especially mining exploration companies, is what about flow through? What's the federal government going to do? As you know, all companies that conducted a financing in 2019 and issued flow-through shares would have had to renounce to the flow-through in favor of the investor for before February or March of this year, for that investor to be able to deduct that expense from his 2019 income tax declaration. Well, I can tell you that pretty much every single mining association you can think of in Canada, including PDAC, Mining Association of Canada, the AEMQ, Ontario Prospectors, Ontario Mining Association, everybody has sent in a request to the federal government asking them to extend simply to December 31st, 2021, the obligation that companies had to spend flow through before the end of this year. A good example of that is if you were a mining company in northern Quebec and you had to halt your drilling because mining activities had to come to a stop, and now mining has restarted, you can't go back because essentially the only time to drill in the James Bay area is in the wintertime, because so obviously these companies have lost an opportunity to spend that flow through. So we're all hoping that the federal government will accept this request and extend flow through. But unfortunately, there has not been an official decision made yet to that effect. So that is the end of my presentation. A couple of housekeeping remarks before we go on to a Q&A session. One thing I would like to mention, this is the first of our series of mining webinar series. There will be 4 others to follow. There will be one on June 8th, which is mine financing in the current environment. That's June 8th. On June 15th, there will be a webinar on international mining investments and development. On June 22nd, there will be another session on critical minerals supply chain for clean technology and new economic opportunity. This is what Andrew was referring to before. And finally, on June 29th, there will be a webinar on key ESG issues facing the mining industry. Before taking your questions, I would also like to point out that if we could ask you to to fill out a there's a survey that you can fill out by clicking. I think there's a link to your where at the bottom of your page for you to fill out a survey at the end of this webinar. And for information on the mining webinar series that we are giving, you can register obviously on our website at fasken.com in the mining/webinar/series. And we look forward to, we hope you register, and we hope you've enjoyed this webinar. Let's go on to our questions. I think the first question will be directed to Norm or Elaine from Manuel Tagle. I'm sorry, he's a mining lawyer out of Chile. The question is, if a Canadian parent company has a mining project in operations abroad, how likely is it to be charged with criminal charges in Canada, let's say Ontario, for example, if the company manifestly does not comply with the Canadian COVID health requirements in its operations overseas? So this is either for Norm or Elaine.
Thank you, Frank. I'll try a quick answer, and then maybe Elaine would like to add. We've looked at a number of different scenarios, including COVID-19, for extraterritorial legal responsibility for health and safety laws and standards in other jurisdictions and how it might affect a Canadian parent company, whether it's public or not. Generally, regulatory laws such as occupational health and safety statutes and other employment statutes will not be seen as extended beyond the provincial border and will have either none or very limited extraterritorial application jurisdiction. That is different than criminal law. There has to be a real and substantial connection between the alleged criminal activity outside of Canada to make it a criminal offense in Canada. I was involved in a Court of Appeal decision, a criminal charge in a white-collar case, where the real and substantial connection test was challenged by our client, who was alleged to have committed criminal acts in the US and in India. But the Court of Appeal agreed with the trial court that there was a sufficient connection to Canada for criminal liability to attach and to allow prosecution on the merits. So quickly, for example, if directors, officers, and perhaps senior management located or connected to Canada in a Canadian publicly traded company knew or ought to have known about substandard or even terrible standards of a safety situation in other jurisdiction, then there is, at least in theory, though I don't know of any case to date, for criminal exposure under the Westray Bill in Canada. Civil liability, of course, is a different question that wasn't specifically asked, so I'll leave that alone. Elaine may want to add something.
I have nothing to add, Norm.
Norm, as a follow-up question, I guess Manuel would also like to know: is it possible for under Canadian courts for to pierce the corporate veil of the company, considering how serious worldwide COVID has become?
Right. Piercing the corporate veil is typically a civil law or civil procedure issue. It doesn't really have a place conceptually in criminal law. But just to go back to the criminal aspect of the question, corporations, organizations, and individuals have positive duties under the criminal code under section 217.1. So an individual who had managerial or oversight at the board level responsibility, at least in theory, could be charged individually for a breach of 217.1 of the criminal code and attract criminal negligence causing injury or death charges related to COVID. I think the big issue is not so much the state of the law in criminal regulatory law, but the challenge will be in the COVID context, proof. Is there evidence, number one, that the worker who got ill or died sufficiently could prove that the COVID exposure was exclusively or presumptively at a very high criminal standard beyond proof beyond a reasonable doubt caused at the workplace. Then the secondary argument is really going back to one of my earlier slides, the due diligence argument about what if any laws are in place. Generally, no one has a law dealing with COVID safety precautions. Then you go to public authority, health authority guidance and best practices, and then you look at the legal requirement for policies, procedures, safe work direction. And then once that's covered and you have a good program, the question is, how is it being implemented? So I think there really is an important aspect for every mining operation, every business, the connection to Canada to manage this well, whether you were shut down or continued during COVID, because there is not only criminal and regulatory risk, but also civil exposure.
Okay. Thanks, Norm. Kevin O'Callaghan, I think you wanted to add something to this?
Yeah, the thing I would add on that front is that when you're looking at the application of Canadian standards to domestic standards to international operations of Canadian businesses, the first question you need to ask is the Canadian company meeting the standard in the location? And in the context of COVID, the spread of the viruses and how it is being dealt with in each domestic location is such that just simply trying to apply an Ontario standard to an international operation probably wouldn't work. However, if there were no standards being applied in the country where the operation took place, what companies should likely look to is international standards as opposed to Canadian standards to guide their operations.
Okay, thanks. We have a question now on OHS issues from Joseph Lompré. Has the 2-meter distancing recommendation been codified in any mining safety regulation?
Sorry, Frank, looking for the question. Can you repeat it? Sorry.
Sure. Has the 2-meter distancing recommendation been codified in any mining safety regulation?
Yeah, it's not in mining regulation, but if you go through the recommendation, elaborate by the CNESST, you will find then the distanciation about the 2 meters. And in these guidance, with the CNESST, you will see then if you're not able to respect the 2 meters, then you can apply the individual protection equipment, and then the workers will be allowed to continue their work.
Okay, thank you. Are there any other questions from our participants? Okay, well, listen, just a reminder that you can fill out a survey at the bottom of your page. We hope you can do that. Your feedback is important to us in an effort to improve our product. We hope that you have enjoyed this webinar. They're our first of our series, and we look forward to you participating in our next event. Thank you very much, and have a great day.